Welcome to the HR Empowerment Podcast, where we will uncover strategies and new insights from HR professionals who discuss up-to-date regulations, best practices, and the most pressing topics like diversity and equity, leadership, dealing with difficult situations, and much more that affect your bottom line and business. Thanks for joining us.
Hey everybody, Wendy Sellers here. Welcome back. The HR lady. We are here today with one of my favorite employment attorneys ever. And I don't even mean this just to be, getting better information. You really are just so raw and honest and helpful. Welcome to the show, David Miklas.
Thanks for having me back again, Wendy.
Hey, tell our listeners a little bit about yourself.
So I'm an employment attorney. I've been doing this for 27 years, representing only Florida employers this entire time. And I'm still busy. I'm very busy. I'm not looking for new clients. So this is kind of my way to give back and give some free information out there.
Absolutely. And the topic that we're going to be talking about today, it's not only relevant in Florida, it's all across the country, in theory, the world, but really the laws are the country. So listen now, hang on tight, everybody. We're going to be talking about diversity, equity, and inclusion. And we're going to be specifically talking about what HR managers and business owners need to know from a compliance, risk management, and workplace culture perspective. So hang on to your seat. We're going to jump in quickly here. My first question for you, David, is many employers are hearing conflicting messages about DEI and many other letters that often follow as well. What has actually changed legally in the last few years? First question, and then what are the biggest misconceptions of HR professionals and managers that we need to be aware of?
Sure. So a Supreme Court case came out called Ames versus Ohio Department of Youth Services. And in that case, the court unanimously ruled that all employees, including majority group members, face the exact same evidentiary burdens in Title VII discrimination claims. So this Supreme Court decision essentially eliminated a higher standard, a heightened standard that was called the background circumstances test that had been used for whites and for men who were alleging discrimination. And this is important because it makes it easier for white people and for men to file what's called reverse discrimination suits against corporate DEI initiatives. And now there's an intense scrutiny of DEI programs across the whole country, especially where initiatives favor certain demographics over others, which can constitute actionable employment discrimination. Not always. Not all DEI programs are per se illegal. It's the way that they're set up. Some are doing things perfectly fine and some are not. So as a result, what we're seeing now is a shift towards merit-based employment decisions. That's really what HR wants to focus on, because after this Ames case, companies should be making sure that all their employment and promotional decisions remain strictly based on merit, consistently neutral, and applied equally to all demographics.
I mean, that makes sense, though. I mean, it should always be based on merit, even though DEI was intended to help people that, may have not gotten advantages in life earlier. But this definitely, I was reading, it was, I think it was a 2024 survey by SHRM that said even then that many employers were already reevaluating DEI initiatives due to all these court cases. So has this Supreme Court, the Ames versus Ohio, was that going on for a long time?
Yes, but until the court rules on it, no one really knows which way it's going to go. So I don't think that in 2024, SHRM's position was based on reading the tea leaves, other than the fact that once Donald Trump became the next president, Trump 2.0, things started to align with SHRM. And that's where they dropped the E out of DEI and they're focused on the D and I, and I think now they throw in a C for compliance. But frankly, the E is where the problem is. No one really has a problem with diversity in the workplace. No one has a problem once someone's in the workplace trying to make them feel included. It's the equity part of DEI that people have gotten wrong. And not always, but that's the part that when they get it wrong, it's because they're trying to do equity and they're just doing it the wrong way.
Right, because they're not experts in that and they're just flinging out a policy and saying, let's go with it. So, this is why it's very important for our listeners. I don't care if you have one employee or you have 1,000 employees, you really need to be having an employment attorney on your side, looking at your policies, your practices, and or at a minimum, just following one on LinkedIn, right?
Right.
David, who posts all the time. So, I have a big question for you here. What are the biggest legal mistakes you see organizations in Florida or across the United States make when implementing these DEI initiatives?
Okay. And this really is a sea change for how HR folks have been doing things over the last 4 or 5 years. Some of the things you're going to hear me say might be the exact opposite of what you may have heard at conferences 2, 3, 4 years ago. But what I'm about to say is what's going to help you avoid getting an EEOC charge of discrimination or a finding from the EEOC adverse to you. So risky things right now are if an employer tries to balance the workforce or gives preferences based on a protected characteristic or stereotype. And just very recently, in 2026, the EEOC announced that it was investigating the shoe company Nike for DEI-related race discrimination against white employees and applicants, and even participants in their training programs. So, Wendy, what I'm talking about is race-restricted opportunities such as mentoring or leadership or career development, and they're allegedly giving preference to one race in an internship program or in hiring or in promotions or layoffs or demotions. An example would be having an internship program that requires 50% of selected participants to be from an underrepresented racial group or female students. Those things are quotas. That's what's illegal.
Yes.
And in June of 2026 just happened, the EEOC announced a big change. They used to have a 5-year plan called the SEP, Strategic Enforcement Plan. They scrapped that. I think it just allowed them to be able to not have to comply with it for the next couple of years because it was supposed to go all the way through 2028. But they now have something called the National Enforcement Plan, and it's supposed to span 2025 through 2029. And the reason I bring this up is because in there they talk about national origin discrimination and some other stuff. But the key things, there's 4 areas in there that specifically focus on DEI related things. One, the EEOC has announced that they're going to be focusing on discrimination in job advertisements that encourage certain individuals to apply based on race. For example, blacks or Hispanics or diverse candidates or other terms that are functionally equivalent for race-based selection. 2, race or sex-based quotas, including practices that might just be labeled aspirational goals that are what the EEOC says might be proxies for actual quotas. In a recent example of a sex-based quota in 2026 is seen where the EEOC announced that an employer paid over $1 million for hiring 97% female servers. Now they hired some men, but they stuck them in the back of the house. So imagine replacing female with blacks and whites. I mean, imagine if I said, okay, well, we'll hire some black people, but we keep them in the back where no one sees them and keep all the white people in the front. That's outrageous, but that's exactly what was alleged to have happened with men and women. Now, another example is requiring job applicants to demonstrate cultural competence or lived experience or cross-cultural skills. And the EEOC is saying these things are a proxy for racial or ethnic backgrounds, which really should not be factored into hiring or promotion or things like that. The third area that the EEOC's National Employment NEP is focused on is limiting access to internships or mentorships or training or advancement opportunities. And this would include employer-sponsored groups or events. You may have seen in the news a Coke bottling company got nailed because they had a special event for women, and it was basically a perk of employment. It was at a resort, a casino and resort, and that's a nice thing. A lot of people like to go to a resort, but they only let women do it, and they said, well, it's for women leadership. You can't do that kind of stuff. You can't exclude other groups, even if you're trying to give a leg up to one group. And then the fourth area is incentivizing the use of race or sex in employment decisions, which may include having a policy to have what's called a diverse slate of applicants or even a diverse hiring panel. So, for example,
Oh.
if you have a policy that, hey, at least 2 underrepresented minority candidates need to be here, or if we require a certain percentage of finalists to be from diverse backgrounds. Also, falling underneath this fourth category would be policies that require candidates to submit diversity statements. Also, a no-no would be sharing employee race or sex data with managers or other non-HR personnel or legal that really doesn't need to know. Why would a manager that's hiring someone need to know the gender of the person or the race? They really wouldn't need to know that. So even if you collect that information, even if you have it, you shouldn't be sharing it with your hiring managers. They don't need to know. Also, normally we say rubrics are good, but if you use a rubric to evaluate candidates that includes protected characteristics, like giving a leg up to someone who comes from a certain background, that would be, focusing on something that the EEOC is going to be coming after you for. Also, if you tie, and this is something that's a big change, I think for a lot of HR people, if you tie compensation or bonuses to employee race or sex-based demographic goals, or other kind of diversity goals. Hey, we want to have more women in leadership roles. We'll give you a bonus if you help us meet that goal. That's a proxy for quotas. And there's a lawsuit filed in 2026 on behalf of white men in Philadelphia. These police officers are claiming that the employer implemented a DEI promotional policy that allowed blacks and women to bypass higher ranked white male candidates. And the goal is the goal in that case was arguably benevolent. It was an effort to ensure that the racial and gender makeup of the city's police force mirrors the city's population. So regardless of the goal, it doesn't matter. If you're going to hire someone with lower qualifications due to race or gender, that's going to essentially be a quota that's going to be illegal. And pretty recently, back in 2025, Andrea Lucas, the chair of the EEOC, put out a document on the EEOC website called What You Should Know About DEI-Related Discrimination at Work. Anyone can Google it, and in there you'll see it asks a question: when is a DEI initiative illegal? And the answer basically is under Title VII. So it's not under Donald Trump or under Andrea Lucas. It's under Title VII. An employer policy may be unlawful if it involves an employer taking an employment-related action that's motivated in whole or even in part by race or sex. Now, another big area of risk right now would be having affinity caucuses that are segregated by race. There's not necessarily a bad thing by having these groups. The key is how you structure them. So if you have a DEI training program that requires participants to separate into race-based groups, for instance, a Black employee caucus or a white ally group, that's segregation. In March 2026, an employer in Illinois agreed to pay $500,000 to end a DEI-related investigation involving this. Also, there's evidence of derogatory statements targeting white employees, such as they are white and they don't feel racism the same way that non-white patients feel it. So there's some other stuff there that besides just the separate groups. But another example is a recent appellate case out of the 8th Circuit in a case called Henderson versus Springfield R12 School District, allowing a lawsuit to move forward, and it was claiming that equity training violated the First Amendment. Now, in that case, the white employees were told that they must acknowledge their privilege. And believe me, you might be hearing some of this thing, oh, who would do that? But I promise you, some of these DEI trainings or equity trainings are put on by DEI gurus, really, who aren't lawyers and don't know the law. But let me just give you the facts of that one. So the white employees had to acknowledge as part of the training in order to pass it that they had white privilege. And one of the white participants came forward and said, you know what, I don't believe that every white person is racist. And I don't believe that I'm privileged because I was raised in poverty and I worked hard to accomplish my goals. But one of the trainers allegedly responded that Black people can't be racist. And she did have privilege because she's white. So that case is moving forward. Another example would, and this is the last one, and I'll let you move on, but another example would be DEI training that includes statements stereotyping individuals based on protected characteristics such as all white people are inherently privileged, or using the term toxic masculinity. And I promise you, there's people listening to this webinar that either have attended a training that use that term or put one on. And right now, that's the kind of term that's not going to be useful. I always say, if you're putting on a training, is this bringing people together or is
Right.
it dividing them? And
Right.
generally, if it's divisive, it's probably not going to be a wise spend on your money.
Yeah, absolutely. Whoa, you've given us a lot to unpack there. And you know what? I'm actually not surprised about many of the examples that you gave because even in my past, I probably used some terminology and then I realized, oh, that's not right. That's not right at all. Putting anybody in a box, without understanding their full capabilities is just wrong. I'm so glad that you.
Wendy, I think a lot of people might, and I don't mean to as I'm going through this to make anyone feel like they have been doing something illegal or wrong. I'm letting you know the EEOC is focused on this right now, and they may
Right.
conclude that you haven't. But I do understand when a trainer says, you know what, let's put all the black people in one room because they're more comfortable talking about these black issues if white people aren't there. Same thing with men and women. Let's talk about women feeling harassed and all that without the men in the room. I get the concept that people are more forthcoming if they're around kind of their own kind, but this is segregation, and we're in
Yes.
2026. We shouldn't be having segregated meetings.
I completely agree. And it's about knowing your company. It's about knowing your people. It's about talking to your people, doing surveys, asking them questions and getting to know, okay, what are the issues here and what are we trying to resolve? There's so much. And I love that you brought up, like basically quotas versus goals, and that, yeah, you can have goals, but you can't necessarily reward for goals that are discriminatory. That's really what it comes down to. So important. And then right before we were getting on today, I was literally just working on a scorecard for one of my clients, and I give my clients scorecards to use for reviews and then also for hiring, so that they don't go outside those lines and they don't. No, this is
Good.
not supposed to be on that scorecard over here. Don't put illegal things on the scorecard. Making sure that we stick to it. We are humans. We screw up. If you
Sure.
if you're hearing anything that David's saying, that's where you need to maybe take a note and say, you know what, I need to check my policies. But more importantly, in my opinion, than just the policies are the reality, because not everybody's following the policy, right, David?
Exactly.
Including the hiring manager or the reviewing manager as well. The EOC receives, oh my goodness, I think in 2024 fiscal year it was 88,000 discrimination changes or charges. So they got their hands full right now, and it
Yes.
doesn't seem like they're backing down at all. And I'm glad that we have them there, even if there's some divisiveness. But it's not just about outright discrimination; it's about retaliation too, right?
Yes, that's the number one charge that happens, unfortunately, because and a lot of times it happens after someone complains. Maybe they have a legitimate claim, maybe they don't, but then the untrained manager takes action that ends up being retaliation, like cutting their hours
Yeah.
or giving them bad assignments after that, trying to drive them out of the workforce. And even if there's no merit to the underlying discrimination claim, then all of a sudden you have a situation where you really can't defend the retaliation claim because your manager handed it to them.
Right, absolutely. And remember, folks, your employees in the United States can go to the EEOC and file a charge for free. They don't necessarily need a lawyer. Now, will they get one? Possibly, but they can go and file a charge. It's pretty easy. Can't they just do it online?
Yes, it is very easy, and you're right, it's free. So it's obviously not free for the employer to defend
Yeah.
these, especially if they hire a lawyer to help them. But even if they don't, there's a lot of time involved for HR, certainly, but then the managers getting statements, gathering documents, videos, all that kind of stuff takes up a massive amount of resources and time. And the goal, I mean, of course, I'm a lawyer. I make a lot more money litigating cases, but I try to avoid lawsuits. I make a lot more money fighting them, but at the end of the day, no one likes paying a lawyer every month thousands and thousands of dollars. So I try to avoid as many lawsuits as possible. And you and I both know the best way to do that is to train your managers.
Right. Train your managers, train your managers. And if you are sitting here thinking, "Oh, I need to do some training," well, good luck with you, and lucky you, I should say, because we are on the podcast HR Empowerment, which is sponsored by Over Training Advantage, and we have amazing speakers and trainers there, including myself. So, but even I tune into some topics that I'm like, "Oh, that one's new to me," or "I haven't touched that in a while." So definitely lean into training. Whether you're SHRM certified or not, we all need training, especially on this topic of DEI. Okay, my next question is how can organizations, besides hiring a lawyer, besides redoing their entire policies and training all of their managers, or I should say in addition to, how could organizations create a workplace where employees feel included and respected without the legal risk?
Yeah, and that really is important. So I want to make it very clear. You still can have employee resource groups. You can still have ERGs. Just open them up to everyone. Also, utilize your ERGs strictly for networking and mentorship and business insights, keeping them separate from formal employment decisions. Also, train your managers and supervisors. It might just not be a manager, might be a frontline supervisor, but train them on the interactive process and ensure that those managers immediately send any kind of accommodation requests regarding disabilities, pregnancy, or religion to HR rather than denying them themselves on the spot. Also, I'd recommend that you audit your dress code policy and be prepared to make exemptions for religious attire or grooming practices like beards and headwear. And then also support your pregnant employees. Some employers still have not updated their employee handbooks to address the Pregnant Worker Fairness Act, and managers also need to be trained on this too. So all those things help with inclusion, and inclusion is not just Black people, it's not just women. It's really everything. It's older people that are kind of feeling pushed out. It is pregnant women, especially right now. It's one of the most protected type of employees that you do have. And right now, the EEOC is coming hard for religious discrimination claims, especially against Jews and Christians. So that's why I mentioned the headwear policy and audit to make sure that you do provide reasonable accommodations to make those people also feel included.
Yeah. And I wanted to also stress on that, people with disabilities. I know you mentioned it as
Yes.
well, but I think it's so not understood that, you don't have a choice. If you as an employer have to follow the ADA, which is 15 or more employees, then you have to consider a reasonable accommodation for somebody with a disability. And you and I could have the same disability, but it could be two different reasonable accommodations, right?
Yeah. In fact, I train my managers when I give a training. The first response when someone asks for an accommodation, it's 5 words. How can I help you?
Right.
And maybe you can do what they're asking for, but maybe you can't. But that starts the interactive process.
Yeah, and going back to, the item of not only feeling included but respected, research from Gallup consistently shows employees who feel respected at work report higher engagement. Hello, isn't that what we want? And lower turnover risk. And if you have been recruiting just in the year 2026, and never mind even 2025, it is expensive. It is expensive. So even if your executives are like, I don't want to have everybody be unincluded, and I'm not that soft person, show them the numbers and maybe they will go, okay, I'll listen now, Wendy. Okay, my final question, David, is looking ahead into 2026 and beyond, what should HR leaders and managers be preparing for regarding diversity, equity and inclusion, workplace culture, and even employment law over the next few years?
Okay, so regarding recruiting and hiring, I'd recommend HR avoid prioritizing candidates that come from underrepresented groups for hiring or promotions. Also, when it comes to job descriptions, an easy thing you could do to audit is to ensure that the language is gender neutral and free from exclusionary jargon. An example would be any masculine coded words, terms like ninja, rock star, dominant, aggressive, or competitive. All those kinds of things tend to discourage female applicants. And vice versa, feminine coded words, terms like supportive, nurturing, interpersonal, collaborative, can sometimes skew the applicant pool away from male candidates. So if you're
Oh,
seeing
wow.
all of our servers seem to be female. How can we get more men? Maybe take a look at this. Maybe take the words like supportive and nurturing out of that if you're using those terms. Also, I would recommend in 2026 that you audit aspirational goals, because the EEOC's new NEP directly targets demographic corporate targets, warning that aspirational goals often functionally operate as unlawful race or sex-based quotas. When it comes to interviewing, I'd say require standardized interview rubrics. And we used to say diverse interview panels would minimize affinity bias. But now under the EEOC's 2026 NEP, formal diversity hiring panel policies or candidate evaluation rubrics that explicitly consider protected characteristics are basically being flagged by the EEOC as potential tools for intentional discrimination. So the way to fix this is to shift to merit-based panel selections or objective evaluations, focusing on standard competency metrics without using any demographic quotas. When it comes to compliance and policies, I'd recommend that you allow everyone access to the facilities and resources. This means you better not have any safe space or lounge exclusively for employees of a specific racial or ethnic group. An example I've seen of this would be a BIPOC only lounge or lab or venue. That's going to be illegal. It's also about making sure that resources are not only available to certain groups. In March 2026, the LA School District were in the news for having a group for Blacks that were meant to help achieve racial equity, but resources were allocated according to a race-based system. They allegedly were giving resources and support dedicated to the social, emotional needs of only Blacks. So you better not have DEI-focused workshops that is for underrepresented minorities only. That's the key. If you exclude people, that's segregation, and that's what we don't want. And I'd also recommend that we have a review of all leadership bonus structures. So it's a risky practice now if you tie a manager's compensation or bonuses to demographic hiring or promotional targets. So HR should take steps to de-link, separate out executive pay from diversity metrics. And then, of course, we always talk about employee handbook reviews. I check to make sure that the policies include robust, gender-neutral parental leave, not just for women, flexible working arrangements, comprehensive religious accommodation guidelines. And that's really the key that I think would be useful moving forward in the world of a huge target on anything with the letters DEI on it.
Yeah, we've got a lot to do in our organizations, don't we, David?
Well, if someone listened to this podcast and learned one or two things today and they could make a change that might help their organization avoid a lawsuit, it was worth their time listening, right?
Yeah, absolutely. One or two things. My goodness, you just gave us like a master's degree.
Well, they can listen to this 2 or 3 times also.
I have a feeling I'm going to be writing a LinkedIn article out of this too, because this is a very, very, very important information here. I was writing down notes myself, about gender neutral terminology, racial neutral terminology. It's so important to realize that our country has shifted. We're not saying you can't be diverse. We're not saying you can't include people. It's just that you can't exclude people. Is that a good summary?
Yeah, yes. And a lot of people follow me on LinkedIn and I do talk about some controversial things, and people sometimes don't like the topics I talk about, but I'm not coming up with this stuff out of thin air. I didn't come up with the new NEP from the EEOC. This is what the government is now focusing on. Whether or not you like it, whether or not you agree with it, this is the stuff that's risky to continue doing right now. So that's why we should be talking about it.
Yeah. And thank you for bringing that up too, because I'm the same way. I'm like, okay, we need to know what the laws are and then how we can safely work within those parameters. And so what are your thoughts on if somebody did have a robust DEI program, should it be rebranded as just D&I or just inclusion?
Honestly, I think the term is beyond repair. I think there's been so much damage done that I really don't see it being rehabilitated. If people have to spend 20 minutes trying to explain what equity really is and show pictures of people on little boxes next to a fence, it's too hard. I think the focus really, if you use any of those terms, it's going to be a target. Doesn't mean that you still shouldn't strive to have diversity when you hire and promote, and inclusion when you have a diverse workforce. Those things are always good. The key is, if you continue to train the way you used to, and if you continue to have employee resource groups that segregate, that will get you sued moving forward. So some of these DEI programs, and I'm just using that term, but it could be any kind of program, whether you call it an equity program or advancement program or whatever you guys call it. The way you run it still has to comply with the law. And the stuff I talked about basically means that anyone can claim that they're a victim of discrimination. And a lot of people don't like the idea of white men claiming to be victims because they've had so many advantages and privileges and steps up and all that kind of stuff for so many years. But at the end of the day, there are white men that are suing, and they're making money. If they're not winning cases yet because they're still in the pipeline, they are settling them and making money. So this is a real viable threat moving forward.
I have one final pop question here, pop quiz question, just to kind of wrap this up, because so many companies were focused on, diversity goals, not quotas, but goals. Can a company still set diversity goals without creating legal liability? What's your opinion on that?
I think so, but it's going to be a target. If you put something on your website that says our goal is to have 50% women in leadership by 2030, that can be used as evidence of discrimination. If there's something else there, if there is an example of a man who claims he didn't get the promotion because of this DEI program, it's going to be not just in and of itself the policy, but if you continue to put that stuff on your website, the EEOC has already illustrated examples of when they go to an employer's website to use that against the employer.
Wow, thank you for that. This has brought a lot of clarity, as well as, whoops, we need to do a little bit more research and probably analyze a lot of stuff in our companies. Well, David Miklas, labor and employment attorney, who is defending discrimination, harassment, retaliation, EEOC, FLSA, handbooks, trainings, and non-competes. This was amazing. How can our people connect with you?
Just look me up on LinkedIn, or you don't even have to try to connect with me. Just follow me. I'll show up in your feed. I post regularly, and thanks for the attention.
Thank you, by the way, just for posting regularly, because honestly, you're giving a lot of us free information on a regular basis and food for thought to say, I might need to make some changes, or, yeah, I'm doing it right. That's awesome. Thank you again so much for coming. I hope this podcast session has been beneficial and helpful to everyone. Feel free to share and listen on YouTube, Apple Podcasts, Amazon, Spotify, or directly, you could go onto the Aurora Training Advantage website. Take care, everyone, and thanks for joining us. Take care, David.
Thank you. Bye-bye, Wendy.